Well, now it's my turn. My name is Sandra Inês Feitor. I am a Portuguese lawyer, a master and PhD in family law, assistant professor of Lisbon Lusophone Law University, and a researcher at the same university, a board director member of ICSP, International Associated of Brazilian Family Law Institute, and Happy Child Brazilian Association. And my presentation will be about parental alienation, domestic violence, and shared parenting in Portuguese courts. So today I decided to bring a case presentation for discussion because there are a few situations that are worrying me very much happening in Portuguese courts. At the beginning, I thought it was very good that our scientific and legal community were more open-wise for parental alienation cases. Although I start being faced with situations where parental alienation is being misconfused with situations of real domestic violence. And without the discernment to distinguish between what is a parental alienation behavior inside of a kind of high parental conflicts and what is a criminal behavior, some courts are applying shared residence of the child with convicted aggressor. I'm not talking about false accusations of domestic violence. I'm talking about proven facts by court sentences that convicts an aggressor by a crime of domestic violence. It extends the scientific literature on parental alienation. I used to call it on negative interference on the establishment or maintenance of family life and affection with the children and a behavior of exclusiveness of relation and affection, where to love one is to betray the other. Parental alienation is real in our society and family law courts, whatever, I just stopping this. Parental alienation it's a real fact in our society and family courts, whatever we want to call it. However, I am being faced with serious situation of opportunistic allegation and abusive use of parental alienation concept to cover situations of domestic violence. And this allegation parts from the convicted aggressor. But what worries me, it's being accepted by judges, by public prosecutors, and for the technicians that give assistance to the court. They are multidisciplinary technicians from social service and psychologists. And I was also faced, and this is the most severe situation I had, and I am sorry, but it was so serious, I guess, that I needed to make a formal complaint to the Forensic National Institute and to the Psychologists Bar Association, because when we have forensic expertises, it's that expertise. It's not just a scientific knowledge that that professional have. It's more than that. It's a specialized knowledge which must to comply with scientific rules and scientific evidence. And when I see a professional who should be at least specialized because it's an expert that is making evidence to the court, that doesn't know the scientific literature on parental alienation, wherever it's its position about the matter, like it or not, accept it or not, it's something that we cannot deny, that it's common on the scientific literature that when we have a real case of domestic violence, of sexual abuse, or child maltreatment, there's not applicable parental alienation theory. This is basic. So the problem here is we have a bias on expertise and consequently on the evidence that is made on court and is accepted critically by the judge, that also doesn't know to distinguish one thing from another. So this has leading to severe situations of establishment of shared parenting and shared residence of the child with the convicted aggressor, even clearly violating Istanbul Convention rules and grave recommendations, among others, which Portugal needs to obey because they signed the convention. So today I brought two cases to make the comparisons, one good and one bad. The arguments, to compare the arguments of the court on this specific situation. And this case study that you can see here, it's the bad one. The case is that the parents got apart in 2015. By agreement, they fixed the model of shared residence. That's okay. The problem starts in 2017 when the child is filed in a child protection case because the child is exposed to domestic violence between parents. So after separation of the parents, in a model of shared residence, occurs a situation of domestic violence. And in 2020, court technical advisory states that shared residence should not be changed because it would intensify the stress and violence between parents, which horrifies me more. You will see why. In November of 2020, the child protection case is dismissed based on this report because the court think that this child who is exposed to domestic violence, real domestic violence of the parents, it's not in danger. So we are dismissing psychological maltreatment for the child that is considered in Portuguese criminal law, as well in Istanbul Convention, the situation of child testimony or indirect victim of domestic violence that deserves protection. 1 month previously, in October of 2020, this father has a restricted order in criminal case and he cannot contact with the victim in a case of domestic violence. However, this order is not respected by family courts that maintains the shared parental responsibility jointly. Parental responsibility in Portugal subdivides in two situations. The parental authority, which means that parents need to communicate between them and decide by mutual agreement the relevant situations of the life of the child, and the physical custody. So they had a shared parenting authority jointly and shared residence. So the court didn't change that. In June of 2021, the father is finally convicted by the crime of domestic violence and accessory measures of restricted order of contact and proximity with the victim. But family court still doesn't change the parental model. So these parents, in light of family court decision, are breaching the criminal measures, which also it's a crime. Because family court didn't respect the criminal court decisions on this matter. So these parents must, in light of family court, to communicate in between them, and its child will still exposed to situations of domestic violence, like it will happen after his conviction, because one day he was picking the child that was with her uncle, and the father thought that her uncle was laughing of him, was joking on him. It wasn't, but even if it was, it would never justify his behavior, because he punched him in the face in front of her daughter. So this person, as impulsive behavior, cannot control himself, cannot control his anger, have an impetus violent. And the family court knew that the more severe situation, that's based on that, the family court decided to maintain the situation of shared parenting and shared residence of this child with the parent, trying to avoid the exposition of the child to new situations of domestic violence, trying to control the violent impetus of the aggressor, the convicted aggressor, saying that the shared residence that they already had in 2015 could help the child stay exposed to future episodes of violence, subjecting it to new episodes of indirect violence, since the father, being very zealous of the routines and care to be provided to his daughter, in case he was deprived of the more regular contact with the child, would tend to exacerbate the suffering and exhaustion that he already feels today, and that would be extreme, possibly target the child's mother. So basically, the children was well adapted to the conflict. What this means, the child is being well adapted to the conflict. We are not talking a parental conflict. We are talking about a criminal behavior. This is became normative for this child. Aggressive behaviors. That's why she will adapt to this scenario, or she is used not to be protected by the judicial system. They had shared residence in 2015 and still have, after that, after the conviction, being violated the rules of Istanbul Convention, with the argument that for maintenance this shared residence, because it's better live like it is, not to provoke the violent impetus of the aggressor. So is this the fundament of shared parenting and shared residence? I guess not, because if we could see previously, no, more. We have several legal rules that states that should not be applied shared residence in situations of criminal behavior like domestic violence. The first one is the recommendation of Council of Europe from 2015 that recommended implementation in European courts of shared residence as a preferable model, but expressly exclude it in situations of domestic violence, sexual abuse, and child maltreatment. Of course, if they are proven, like it was this case, the father was convicted and the court knew it about. Istanbul Convention, it's clear. There are several recommendations from Grevius and committee of the parties that make the fiscalization and implementation of Istanbul Convention on European countries. Namely, in 2017, this one, yes, before. In 2019, we implemented in Portugal Istanbul Convention in 2017, and it's still not being respected in some cases. There are several reports from Grevio, including recently in the third trimester of 2022, referring that finds that many countries lack enough protection for children and domestic violence victims, Grevio, which monitors implementation of the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence, Istanbul Convention, has published an annual report focusing on child custody, visitation, and domestic violence, draw from its evaluation thus far. And is making several notes and claiming for attention for the countries and the courts, national courts, that these situations, child's victim, indirect victim, needs to be protected, which means it must be a revised model of family contact. And in some cases, at all, it's not admissible a shared residence in this situation. But of course, family life is a fundamental right, but it's not an absolute right. So in these situations, it must be rethink the model that is applicable to these scenarios. It must be restricted the time of visitation, and sometimes it can be suppressed or even be under supervision, under technical supervision in institution, because we cannot use the fundamental rights of family life of the child to at the same time trying to promote their fundamental rights and their personality rights, being the same time putting the best welfare of the child in danger. It's not possible to protect the child when we are exposing the child to new situations of domestic violence. And that's why I brought another case to make the difference of interpretation. And this is a good one. I'm sorry, because I already missed my documents. Well, the second situation, it's very similar. The father was also convicted by domestic violence, and the interpretation of the court in this case is that shared parenting, shared residence, and sole custody with the aggressor is not possible because the court states that a situation of domestic violence, the court should completely rule out the possibility of fixing the child's residence with the aggressor parent. This will be the case in cases where the child has been direct victim of violence for obvious reasons of individual protection, which being so obvious do not need any further clarification. And also by exposing the child to experience of violence and aggression, the aggressor parent moved away from the secure attachment model, which, as it is the most favorable to the healthy development of the child, was required for him to profile himself as a possible guardian. To that extent, he is not in a position to ensure the child's residence as a context of affection, sharing, protection, and security. And this is it mainly, because if we fix a shared residence model in this specific context of real situations proven by conviction of the crime of domestic violence in the first time, and in the first case, I need to note this, the first case I presented have a huge argumentation that in theory, that is right, because it always talks about the shared parenting and shared residence as the best model for parental alienation situations. That's only one problem here. This is not a parental alienation case. This is a domestic violence case. This is not a parental conflict case. This is a criminal conflict behavior. This is the difference. So to these different situations, we cannot misconfuse. These are two realities that are very connected one another, but we cannot misconfuse them. Because when we create a situation like this and make this kind of misconfusion, or even we don't make this misconfusion, but regarding the implementation of the fundamental right of family life, which is not an absolute right, and expose the children to a shared residence with the aggressor, we are giving a message to this child that it's that her psychological welfare doesn't matter to the court or society, but her psychological welfare, it's everything, because it's through her parents, her models, her rules, her internal development that the child will form her models, her personality, her auto-concept. And when a child takes, or as it's no importance to be victim, or this is normalized behavior, or my psychological welfare doesn't matter, there is a huge probability of transgenerational behaviors. And this is scientifically proved by psychology. So we need to take very care with this situation, to pay much attention. And I think most of our legal professions doesn't know very well what is parental alienation, what is domestic violence, what are the effects, psychological effects and trauma in each situations and situations of toxic stress. And most severe of all this, they knew the law, but they option for violate the law. And we have specific rules on this situation that it starts to being very difficult to switch the positions of the court because they start being like autists when we argue that they are violating the law. It seems it's more important to stand the ground than correct the situation. Thank you. Sim, sim, sim. Agora, sorry, now I'm going to call to this round table Petra Sofia Ferreira.